So we're back again on this employment law issue. I think most of the members of the committee have probably been somewhat aware of this in the past. This year what we've got is out of the House, we've passed something that was had a few less issues in it. I still believe there are some issues that need to be discussed further. Continue to remain receptive to any discussions on compromise on trying to get something that possibly the governor would not oppose in this area of the law. The one thing that we do have in here that has been really contentious was the contributing versus motivating factor standard. And this bill does have the motivating factor standard being in this as part of the change to the law. We also have a minor clarification as far as what defines an employer. And then the other significant thing to note is the damages caps that are in place in this, and the fact that we have gone to a much higher cap on damages in this case. I mean, the non-economic damages now parallel a lot of what you see in the punitive damages arena, with it being the non-economic damages being capped at the greater of $500,000 or 5 times the award of the actual economic damages that are awarded. And then this also includes in it at the end the whistleblower. You'll note that this year, rather than having the whistleblower codification be within the Missouri Human Rights Act, we now put it apart in its own section of the statutes, so as to clarify that those aren't underneath the same, so that those types of claims are not being reviewed by the commission or affected in any way by that other area of the law. We have made some changes in the whistleblower thing to further address some concerns. People were concerned about what if an employee was reporting something that they thought was illegal when it actually wasn't. Before we said that it had to be an actual illegal act that they were reporting. Now we've put in that reasonable person standard. It's something that the employee reasonably believes that would be, the employee reasonably believes that the employer is engaged in some sort of illegal activity. And we also have put in here the caveat that they have protections if they're instructed to carry something out and they don't, because it would be illegal, then they also have protections underneath the whistleblower. With that, then we go further and match the damages that were stated beforehand underneath the Missouri Human Rights Act. And those are the major components of the bill. With that, I'll yield the question.
Questions for Representative Elton? Seeing none, do you have witnesses to call?
I believe we do have a few here today.
And should we just go in as they arrive? Or?
Yes. Okay.
Thank you, Mr. Chairman. Members of the committee, my name is Rich Aubuchon. I work for Polson-Ellie Law Firm, and I represent the Missouri Chamber of Commerce and as well Enterprise Holdings. This is an important matter for my clients, not only Missouri Chamber and Enterprise, but also many of my other clients who are engaged in active litigation in the employment law context on a daily basis. We'd like to see something done. Of course, here we are, third time's a charm, right? That we've gotten to this point where we have... We're at 3 strikes, you're out. That's right. It's good to have humor. We'd all die without it. The fact is, this is a serious matter. Frankly, we're trying to find some approach. And I know we've had good discussions with members of the committee and others about how to get there. That would make the governor sign the bill. And it's been vetoed twice, right? And its current form is a little different, but maybe not enough for the governor to sign that decision of approval. We'd like to do anything we possibly can to come up with that solution to have the governor approve this legislation.
Other questions for this witness? Senator Schmidt.
Thank you, Mr. Chairman. Actually, this would be for the sponsor. So let me just make sure I understand the differences this year versus where we were last year. I guess the whistleblower section has been set apart in a different section. Is that right?
That's correct. Yes.
Okay. And then the non-economic damages number is $500,000 here. What was it before?
Before we just had a cap on damages of, I think, $250,000, if I remember correctly. We just had an overall cap on damages.
So that included economic and non-economic?
Well, it didn't include economic, but it wasn't exactly clear. We had some discussions with different House members. Maybe there was a semicolon needed, some things like that. So we've gone further this year to clearly identify that those are separate damages, economic damages would not be capped. You recover what your actual economic damages are.
Okay, so it's either 500,000 or 5 times the amount of economic damages,
Yes, that would be for the non-economic.
whichever's greater. Okay, and then what other significant changes are there?
Well, I mean, we had some other areas that have been dropped out of this, so we've got some debate that's not continuing this year with those. But I would say just the fact that we've revised the caps, we've tried to address the concerns in the whistleblower, what employees are protected are the two major things.
Okay, all right, thanks.
Other questions for this witness? Seeing none, thank you for your testimony, Rich. Are there other witnesses in favor of 320?
Mr. Chairman, members of the committee, Ray McCarty, President of Associated Industries in Missouri, want to go on record in support of this legislation, and also we're continuing to work to try to find some compromise here. We hope we can. I also have a witness form to save you time from the retailers and the grocers association. If I can answer any questions.
Any questions for Ray? Seeing none, thank you.
Thanks.
Other witnesses in favor?
Thank you, Mr. Chair, members of the committee. My name is Jane Drummond. I am an attorney in private practice here in Jefferson City, and about 95% of my practice is comprised of employment litigation. And in the interest of full disclosure, I do litigation on behalf of employees and employers, so I represent both sides under the Missouri Human Rights Act. And I have a client that I'm here on behalf of today, the Missouri Intergovernmental Risk Management Association, and I want to talk specifically about some of the things that I think this bill fixes for employers. Because right now, the landscape is very unfair to employers in employment litigation in Missouri. For quite some time, it was unfair to plaintiffs, I'll be honest with you. For a long time, the statute was interpreted as not providing a right to a jury trial to employees, and everybody had to go to federal court, and a lot of cases got dismissed on motion in federal court, and plaintiffs really didn't get a fair shot. And then in 2003, the Missouri Supreme Court changed course and said, no, plaintiffs should have a right to a jury trial under the Missouri Human Rights Act. And the pendulum swung back a little bit to make the playing field just a little bit more fair for the parties. Well, what's happened since 2003 is the court keeps chipping and chipping and chipping away, and now the pendulum has swung very far in favor of plaintiffs to the detriment of employers. And I think that what this bill does that makes everything a lot more fair is it gets rid of this contributing factor standard that is a very, very low bar. Motivating factor is the standard in federal law. It's worked well in federal law and in many states for a number of years. And what happens is with the damage potential under the old statute, the provision allowing the plaintiff to recover their attorney's fees, and this very low standard of proof, what is happening is employees are leveraging very marginal cases and extracting pretty high settlement value to employers on those cases. Because the mantra is, if I take this marginal case to trial and I get $5,000 from my client, I get $100,000 in attorney's fees. So you better settle this case for $30,000, $40,000, $50,000. And that is what is happening in my practice every day. The employers that I represent are paying way more than these marginal cases are worth to avoid the expense and the risk of paying attorney's fees at trial. So we like that about the bill, and then I would also like to comment on the section that removes or exempts political subdivisions from the punitive damage awards. And we think that is important because some of these punitive damages awards are excessive. We're talking hundreds of thousands and millions of dollars. And when you're talking about a political subdivision, you are basically transferring tax revenue that has been collected for the good and the benefit of all to one individual for one lawsuit. And I don't think that's good tax policy. I don't think that's good use of public funds. And so we think that provision is important to shield some of the municipalities, especially smaller municipalities who just cannot afford those kinds of damage awards and still maintain public services.
Thank you for your testimony. Other questions for this witness? I have one, Jane, before you excuse yourself. So what, in your opinion, you've seen both sides, what are we searching for here? What is it that we want to accomplish in the legislation?
I think what we should try to accomplish is a playing field that gives plaintiffs a fair shot. I mean, I think we can all agree that we don't want people to be harassed or discriminated against in the workplace. So we don't want this to be a state where that occurs. So people that have legitimate claims of harassment and discrimination where a protected class such as their age, their disability status, their religion, their race, are motivating employers to not hire, not promote, terminate, where that is occurring, I think plaintiffs should get to a jury and have a jury hear that case and decide those claims. What I would like to see go away is this leverage where, okay, so you have a boss, a supervisor that jokingly refers to somebody as old man a couple of times, and then that guy doesn't get a promotion. Well, suddenly he can say, hey, I just have to show age contributed. He called me old man a couple times and I didn't get my promotion. I have a viable claim. I get to a jury. If I get $5,000, my attorney gets $100,000 in fees, so you got to pay $50,000 to get rid of this case, because that's what's happening.
And how close do you think we are with this?
I think this bill, I think the combination of the motivating factor standard and the changes to the damages provisions, I think makes it a very much more level playing field than we have today.
Thank you very much. Appreciate your testimony. Are there other witnesses in favor?